If your tenant's air conditioning breaks down in a Nevada summer, you have 48 hours to fix it. Miss that window and your tenant has the legal right to hire someone, make the repair themselves, and deduct the cost directly from rent. That's not a threat, that's Nevada law. Nevada's habitability framework is built on Chapter 118A of the Nevada Revised Statutes. As a landlord, you're required to maintain the property in a habitable condition throughout the tenancy. That means complying with building and housing codes affecting health and safety, keeping plumbing, electrical, and HVAC systems in working order, providing running hot water, maintaining working smoke and carbon monoxide detectors, keeping the property free from pest infestations, and maintaining common areas and adequate trash receptacles. When a habitability issue comes up, the tenant must give you written notice. For general health and safety conditions, you have 14 days to make the repair. For essential services, water, heat, air conditioning, or electricity, you have 48 hours, provided the issue wasn't caused by the tenant. If you miss those deadlines, Nevada gives tenants powerful remedies. They can repair and deduct up to 1 month's rent or $500, whichever is greater. They can pursue rent reduction through the courts. They can recover actual damages. And for essential service failures, they can terminate the lease entirely. Nevada also prohibits retaliation. You cannot raise rent, cut services, or start eviction proceedings because a tenant exercised their legal rights. If your property is in Clark County or the city of Las Vegas, local ordinances add requirements beyond the state statute. Make sure you know both. For the complete Nevada Habitability Guide, visit tenantscreeningbackgroundcheck.com.